My husband recently passed away. Sorry to hear. We have a will and a trust, which I am the beneficiary. Okay, good. But I never put my name on the deed. Uh-oh. Do I have to probate the will? How do I transfer the deed to myself? Okay, first steps first. You have a trust, but you never moved title of the home into the trust. If you weren't on the deed, that might be fine. Did your husband, since his name was on the deed, the home is legally his, regardless of community property, his name's on the title, did he ever transfer that home into the trust? That's what we need to find out. So I need you to come back to me, email me or send me the message the same way that you sent, and let me know the address of the home, and I can tell you right now whose name is on the title. I can look that up. But if that home wasn't moved into your trust, then there's two things we want to do. We don't want to probate the will. That is such a costly, long thing to do. Probating wills suck. Really, it does. I'm in probate right now with 5 cases and they're over a year old. They all suck, right? But what you can do is there's something called a Hegstead petition. This is a special petition in California that when you have a trust and maybe your property isn't in it, we can go ask the judge, hey judge, we don't want to do a full probate. We just want to move this property into the trust. And the judge is going to say, okay, Yasha, we're going to move this property into the trust. But in order for me to do that, you need to show me that the creator of the trust and the owner of that property originally intended for that home to be in the trust. So I'm going to have to look at your trust documents. I'm going to have to look at all of your estate planning documents to see if I can find any evidence, something that just says, like on the schedule of a trust, usually at the very end of the trust, there's a listing of the assets that people do sometimes, and they write the address of the home. That's enough. I can go to the judge and be like, judge, no probate. Let's just do this nice and quick. Let's just transfer the home into the trust. You don't need to see anything else. And judges will do that. Okay. Now, if that doesn't exist, if we can't prove that your husband intended to have the home inside the trust, because a trust is a proactive document. Think of it as when you set up a trust, you have an empty shopping cart, right? The people you name as trustees, when you're incapacitated or if something happens to you, they are the ones pushing that shopping cart. But you have all your bank accounts, you have all your property, you have all your Bitcoin, right? If you don't actually transfer that into the trust, put it in your shopping cart, then your shopping cart has no jurisdiction. Your shopping cart does nothing. We rely on your will, whether you have one or not, on top of your trust. So you need to move your assets proactively into the shopping cart. And because you have to do that, we call that trust funding your trust. Then a court will never assume that you wanted your assets in that shopping cart. If you don't move them in, the court is going to think maybe they didn't want them in. Maybe you built this trust for one of your children, but not the rest of your children, you know? So trusts are not huge blanket estate planning vehicles. They are really good tools that will protect you during life and at death. It'll give legal protection to your kids. It'll save your family so much money and privacy, but you got to be proactive about it. So if we don't have something in writing, an asset inventory, a trust schedule, something that showed your husband intends for that property to be in the trust, then we got to go to probate. And that will suck. But if it's your community property between you and your husband, then instead of probating the will, we'll do something a little bit easier. We'll just file a spousal petition, something as simple as like a Hegstead, where you're basically saying, I'm the wife, I'm the surviving spouse, husband died, this is our community property, just push this property over into my name. But if your husband had kids, then there's a little bit a different nuance there. If your husband had other separate property assets, then you can't use the spousal petition. You have to go through probate and probate the will. And through the will, you will get title to the home. Unfortunately, those are your 3 options. I do need to see a lot more of what's going on with your husband's estate in order to give you proper guidance. But there's really, you can't just go to the county and say, change the title into my name. Unless your husband created a trust and put the home in the trust, your husband filed a transfer on death deed, which is like a beneficiary designation for real estate, and put your name on that deed. He can't put the trust name on that deed. That doesn't work in California. Or we have some kind of document showing that he intended for the home to get into the trust. He just never got to transferring it in. If we don't have any of those, then we're in probate. That's as hard as it is. I know it's a little bittersweet. I'm still very sorry about the loss of your husband. Everybody else, that was our 3 questions for the day.